I said we're going to start with Ingrid and Shae talking about competition law, labor law, and GVCs, a case study from Australia. And Kobi Kastiel from Tel Aviv University is going to be our respondent. So as we did yesterday, you guys are going to have 10 minutes, and then Kobi will have 10 minutes, and then we'll all discuss. So the floor is yours, Ingrid and Shae, and thank you so much for bringing us this paper.
Hey, thank you. Hello. I'll just throw the slides up. Okay, that should be right. Sorry, just a moment. Can you still see them?
No, it disappeared.
Sorry, just a moment.
I will say that yesterday we had the Dev Nathan's paper about monopsonies, and it was too late for you guys to be there, but we will have the recording, and it'll be interesting to kind of see the connection between the articles, because his was very, and he did think about regulation, but it was not legal per se, it was kind of economic. So the floor is yours, and we can see it now.
Great, thank you, Hilla. Okay, so thank you again, Hilla, Guy, and Shelley, who I'm not sure if you see yet, for inviting us to participate. And thank you in advance, Kobi, for very kindly agreeing to comment on our paper. So our paper explores the constraining power of national labour and competition law on collaboration between actors in global value chains. And we look at this issue through an Australian lens, and using a hypothetical case study of efforts to improve wages and working conditions within the seafood value chain of Australia's largest supermarkets. So I'm going to talk a bit about the context to our paper, its aims and methods, and introduce our case study, and then I'll hand it over to Shae. Okay. So our paper kind of lies at the intersection of labour law, competition law, and business and human rights. And it's prompted by conversations that Shae and I have had concerning, I guess, that the dissonance between certain bodies of scholarship and regulatory regimes in Australia. So on the one hand, we have in labour governance and business and human rights literatures a growing emphasis on the importance of collaboration and coordination between actors in GVCs. So this reflects a kind of a growing recognition that the nature and complexity and distribution of power within these chains is such that action at the individual firm level, particularly further up the chain, whether by workers or by the firm itself, or even by workers and the firm together, is often insufficient on its own to secure meaningful and sustainable improvements in wages and working conditions. Businesses may also lack the appropriate incentives to take such action unilaterally. On the other hand, we have long-standing and deeply embedded national regulatory regimes in labour law and competition law that intentionally kind of atomise firms and groups of workers, and that render it very challenging for workers to take action beyond the enterprise level, and for companies even to start talking about how they could collaborate with each other. Okay. So in our paper, we seek to unpack in more detail how labour law and competition law operate to constrain efforts within the context of Australian GVCs. We focus on these two modules of law, to use Katerina Pistor's term, because they both have a direct bearing on the capacity of parties, workers and firms to coordinate actions to improve wages and working conditions in GVCs. We focus on Australian law because of our familiarity with the jurisdiction, but also because much less attention has been paid to these tensions than is the case, for example, in the European Union, or even, I would say, the United States. The big question, why prawns? We explore these issues through a specific case study of Australia's large supermarkets and prawn, some people use the word shrimp, value chains, because this enables us to achieve a level of I practiced this word beforehand and I still can't say it, specificity in our analysis that is necessary if we're to gain greater insight into the operation of these two fields of law and practice. Also, supermarket prawn value chains contain a number of features common to many GVCs today. So these go to the geographic breadth of the value chains, the dominance of certain firms within the value chains, and the presence of private governance initiatives throughout, through which lead firms purport to use their market power to ensure responsible production. The existence of suppliers within Australia and internationally also enables us to consider the extent to which labour law is capable of extending beyond Australia's borders, and the extent to which competition law is capable of recognising the connections between Australian consumers and farming and production sites in developing countries. To be honest, I also think it's because we started this paper just before Christmas, and everyone in Australia eats a lot of prawns at Christmas. So I think that's also an explanation for our choice of the supply chain. But before I move on, it's what we've tried to do in this, an innovative aspect of this study is we try to consider the extent to which these domains of law constrain the capacity of workers to take collective action. So the capacity of workers to take collective action and or the capacity of firms to take collective action. So we're looking at both. In our paper, we provide a broad overview of the role of labour law and competition law in GVCs. I'm going to skip over this discussion except to make 2 points. The first is that while labour law and competition law regimes both essentially go to distribution of coordination rights in the market economy, they've always, of course, diverged in their underlying rationales and frames of reference and have long had an uneasy relationship with each other. To date, these tensions have largely been managed through the carve-out of certain aspects of labour market from competition law. However, the size and the boundaries of this carve-out have always been contested. The second point, sorry, I realise I'm reaching time, I'll move up a bit, is that the need for reform to national competition laws has been recognised by policymakers. And this pressure has not come from labour law, This pressure has not come from labour law, but it's come from the kind of sustainability in business and human rights policy domains. So according to these normative frameworks, collaboration is necessary to identify and address labour rights issues, and where businesses discover an issue within a supplier where they can't fix the issue on their own, they're supposed to work with other businesses to increase the leverage they have. So in this context, we have seen some reforms to competition law's overriding consumer welfare paradigm, but this has very much been focused on facilitating inter-firm cooperation, and there appears to have been little appetite among law and policymakers to address long-standing obstacles to worker cooperation and collective action, particularly where it spans national borders. Okay, I'm just going to briefly talk to our case study. So we look at efforts, basically what actors could do to improve wages and working conditions in the prawn global value chains of Australia's two largest supermarkets, Coles Group and Woolworths Group. These two major supermarkets hold about 2/3 of the market share in Australia, and the dominance means that they have a lot of control over suppliers in their value chain. They both, as you can see from figure 1 and figure 2, they both source prawns from Australia, farmed and wild caught, and the prawn supply chain is made up of 6 stages, as you can see in figure 1. And they also source frozen prawns exclusively from Vietnam. And figure 2 shows a kind of a more complex and fragmented shrimp chain in Vietnam. Both supermarkets recognise Vietnam as a country with a high risk of exploitative working conditions, including forced labour, exploitation of migrant workers, deceptive recruitment, child labour and excessive working hours. So they recognise these issues in the prawn value chains. And they both have policies and programs to deliver their commitment to responsible sourcing. However, these programs are very limited in their scale and scope. I'll now hand the floor to Shae to continue.
Thanks, Ingrid. I'm going to do my best to keep to time, but I may stray a little bit. So the first part of the case study, we asked a question about the extent to which employees, workers within this chain, could act in coordination in order to try and impact wages and conditions both domestically and internationally. And we looked at it through 2 lenses. We started with the lens of at the enterprise level. So this would be employees in relation to their direct employer. And we also looked at it collaboratively across the chain. So could workers collaborate with workers at different nodes in the GVC, either horizontally or virtually? And what the paper demonstrates is that at every level workers try to do that. They face the stickiness of Australian labour law in respect of its focus on regulating collective rights through the contract of employment, such that workers' rights are very much restricted to being able to collectivise in respect of people who are contracted to the same enterprise. And in terms of that relationship, only contracting around their own working conditions, not working conditions external to that enterprise. Certainly no boycotting that is designed to impact workers at other levels of a GVC. In fact, that's expressly unlawful under Australian law. And so really we work through the labour law examples in Australia which demonstrate that our system remains stubbornly sticky in respect of only permitting collective action between workers who are employees of the same enterprise, and really prohibiting any kind of horizontal, vertical cross collaboration for workers, either across the chain or up and down the chain. We do talk about some exceptions in there, but they're not particularly promising. And then in the competition space, we then asked the question, to what extent then could the enterprises act collaboratively? Now, interestingly, they could actually choose to collectively negotiate under labour law, but if they did that, that would tend to unpick the value that they have from vertical disintegration. And so we didn't see that as something they'd be interested in doing. So collaboration outside of labour law, however, runs up against our competition law framework within Australia. And so we asked for scenarios, and the scenarios are set out on the slide. So for the interest of time, I'm not going to go through each one. But essentially, in terms of our competition law, which prohibits collaboration, which is of a cartel nature, price fixing, territory sharing, agreements not to deal, boycott type conduct is per se prohibited, and any other conduct that lessens competition is also prohibited. Now, of these four potential collaborations for enterprises, only the first option there would be permissible under Australian competition law, and then only on very, very limited public information, audit information, nothing about business operations or anything else. So even just information sharing is risky under Australian competition laws. But that may be possible. The other three would not be possible without specific authorisation from our competition regulator. And when we look at when the competition regulator would be prepared to authorise, what we find is that the focus is about benefits that flow to the Australian consuming public. And so that has a limiting effect on collaborations that are trying to impact working conditions in the Vietnam arm of our supply chain. And then if we're looking at the domestic arm of our supply chain, again, the difficulties we have around authorisation are market share. Our supermarkets have quite significant market share. One of the paradoxes of our competition laws is that market share, power, the capacity to actually have an effect, makes it less likely that you'll be allowed to act because it's seen as too anti-competitive, right? By contrast to what we understand in a labour law context where collective power, the better the collective, the more power that one has, the more likely you are to achieve outcomes. In competition law, your size is positively working against you if you are attempting to achieve these kinds of collaborations under our competition law. So the paper concludes, after reviewing these areas, that our labour law essentially, its focus on the enterprise, its focus on the employment contract renders it difficult, if not impossible, for workers within a GVC to support the rights and interests of workers in other firms, either at the same level of the chain, but really not in terms of workers in the vertical chain. And our competition law imposed clear prohibitions on firms sharing information or collaborating in any way that might constitute cartel conduct or lessen competition. And authorisation faces difficulties through it must be of benefit to the Australian public and through the way the detriment tests work by our competition regulator. So we conclude that capital may have gone global, but Australian laws remain stubbornly local. Both our labour and competition laws fail to recognise the normative legitimacy of coordinated action, either by workers or enterprises, to improve wages and conditions in GVCs. Indeed, they significantly constrain those efforts. So that was a very quick summary of quite a lot of law. Thank you.
Thank you so much to both of you. And I will give the floor to Kobi for his response.
Hello, everyone. Can you hear me well?
Yes.
Okay, great. So I'm delighted to be here, and thank you, Eli and Guy, for the invitation, and thank you, Shae and Ingrid, for the paper. I truly enjoy reading it, and those are just friendly comments and thoughts. I don't have a PowerPoint, by the way, so I'll try to be short. So I'll just start by telling you a quick anecdote. So when Eli and Guy assigned this paper to me, I told them, well, I'm not an expert in competition law. I'm not an expert in labor law. Why you assigned this paper to me? Can you give me a corporate governance paper? But when I started to read the paper, I realized that it deals with a lot of themes that are of great interest to me as well. And I think if I take a step back and looking at your paper, zooming out, so it deals with the tension between, so we are concerned by corporate externalities, and then the question is how to deal with it through external regulation or through market players. And this is actually the questions you are dealing with as well. I mean, can market players do it? And usually we think about those paths as two parallel paths. And I think what paper shows very nicely is that they depend on each other. So with the regulation, you control the flames. With the regulation, you enable market players to be more active, and so it's not just external regulation that deal directly with the externality, but external regulation that empowers certain market players to do it. So I think it's a very nice example of that, and I enjoy reading it very much. I can also say that, in my context, there are similar questions about cooperation between institutional investors. They are also important market players. Can they cooperate? Under what circumstances? We see them as systemic stewards. So those are, just general thought that came up when I read the paper, and how, and I think the case study is fascinating with a lot of insights. So I really enjoyed it. In terms of the comments, so I think the first one is about the implication of this setting, the broader implication, or I would say the broader applicability of this setting, right? So it's a highly concentrated market. If it's a very specific market, you mention it. So I think it would be interesting in that regard to think about two issues. First, what happened in less concentrated markets? I can give you an example of a student of mine that she was in the closing business, and she said, well, we are concerned about what's going on in Turkey and in the employment terms, but it's a very competitive market. We have a lot of competitors. If we do something, then we can lose our market, we can lose clients because of that. So I think, the question, what happens in less competitive, you mentioned at some point that it's difficult in less competitive markets to cooperate because there are so many players. I think the other question is, is it typical? I mean, you mentioned here in the presentation, but if you give the readers some sense that, well, we see it in a lot of contexts, not just in the supermarket context, we see it in various contexts. So it's give you a sense, wow, this is like a setting that applies in many cases in real world. So I think that's one thing. The other issue is really about what's the applicability of this case study to other jurisdictions. And you mentioned that you focus on Australia, not on other places, but you also mentioned, the EU regulation in this space. And I think it could be interesting to see, how they dealt with these questions, what were their solutions, if we can do, you don't have to go to all of the jurisdictions, but maybe take one or two important jurisdictions, maybe as a future work. and try to see, well, we encounter some problems and now market players deal with them. So I think that's also could be a very interesting part, maybe not in this paper, but going forward. The third issue that I want to highlight, and again, this is an important part in my work, is incentives. So you are under the assumption that the players will have strong incentives to avoid this type of labor exploitation. But it's a question, right? I mean, even assuming in a world that they have no legal barriers, they can cooperate. Will they cooperate? I mean, maybe they can lose clients because of that. It's clear that the price is going to be is going to go up. Will customers still be willing to buy shrimps in those situations? Maybe they will become vegan because of that. I don't know. Maybe it's good. But what I'm trying to say is that, there is also a question of incentives and whether they will have an incentive to behave in that way, especially if we consider cost, especially if we consider trade-offs, especially if we consider the fact that someone will have to bear the prices. And from my experience in concentrated market, the supermarket will not bear the prices. So I think that's another question that it's up in the air. And it's a general concern that is raised every time we do it through the market, and there's the questions like that. I think the other, and that will be my fourth comment, is maybe you want to develop a little bit more the policy arguments, and especially the policy arguments against the corporation. So when I read the paper, and maybe I read it fast, so I missed that part. But you are very sympathetic to the corporation, and I understand why. And I also expressed this type of view when I dealt with institutional investors. But there are strong policy against it. And I think the major concern is that when we have competitors sitting at the same table and collaborating between them on the good things, on the good issues that we all agree those are good causes, but the concern is that they will do also bad things at the same time or misuse it. And I think, you want to develop a little bit in the paper, the argument on the other end, why we should not allow this type of cooperation. And maybe, and that's referred to my, final comments, maybe normative solutions. Under what terms should we allow it? I mean, it can be subject to certain conditions. What could be your prescription in that regards? Under what terms we should be able to do it? And here again, it goes back to the experience in other jurisdictions. Maybe they came up with solutions that could fit the Australian case well in that regard. Now, it's I must say that I also couldn't understand much the concerns against allow employees to push forward. I mean, from policy perspective, the concern in the competition antitrust, the concern against cooperation is clear, and it's a trade-off, and you have to decide how you balance. But in the employee context, it was not clear to me what is even the concern. What's the best argument against allow employees to push it forward? Why not? Why prohibiting it? This is maybe something that you want to develop a little bit more in the paper. It's clear that, if there is a price that employees have to bear, there is a question whether they will be willing to bear this price conducting this activity, and it goes back to the trade-off question. So those are my main high-level comments. And again, I really love the paper. I think it's interesting. I learned a lot from reading it. Yeah, those are just friendly and high level. You won't have enough space to incorporate everything in this project, but maybe in future ones. Thank you.
Thank you, Kobi.
Thank you.
Shae and Ingrid, would you like to respond, and then we'll collect questions?
Yeah, I've got a few kind of thoughts, Kobi. That's really generous and thoughtful and helpful. Thank you so much. It's really interesting. In the first draft of our paper, we did cover Europe and European cooperation around sustainability, but just didn't have the space. So, you've kind of, as you've kind of alluded to, it's sort of a question around space. But the one I wanted to respond to particularly was about developing the policy arguments about why not cooperate. And I guess from my perspective, when I think about that, I kind of feel that competition law itself is the policy argument about why not cooperating. That this policy argument has been completely dominant in terms of the way we regulate in the competition law space, in the prohibition of horizontal cooperation and the dominance that that has had within competition law regulation, particularly since probably the 70s, right? Coming in from that in some ways horizontal cooperation has been seen as the extreme evil of particularly American antitrust laws. And so I think that part of the argument has been aired. I think it's had, it's not only been aired, it's been legislated. And so while I think I see a reason to give a nod to it, I'd be less happy to continue to give more space to an argument that's very well trodden, very well understood, and very well kind of put out in the world. As to why not allow employees to do this, Australian legislators have for a good 25 years been extremely hostile to worker collective action. Extremely hostile. Our laws we have some of the most restrictive strike laws in the world, certainly in the developed world, around that, and that's sort of reflected in the paper, but Ingrid might have more to say on that.
No, I don't. I think you've done a great job. I mean, we do. Thank you, Kobi. I echo Shae's comments that it was really helpful. I do think we do make a lot of presumptions. We kind of leap in at certain points, which again is, partly word length. But I also think, I guess from my view, it's recognising kind of the practicalities of kind of incentives that even when kind of just watching kind of groups work on particular issues, that they can't do it through the labour law. And then they put so much work into kind of bringing market pressure on companies. I was talking to someone about it the other day in the chocolate companies, so much market pressure to get them in the same room. And then in the end, it was the competition regulator said, actually, you can't do that. So I think, so we do, I guess, jump in at certain presumptions.
And I think we need to work on making that clearer, and I think the market question around this market, what about a less concentrated, that's actually really helpful, because actually the competition law analysis plays out differently in a less concentrated market. So
great. So let's open it up for questions. Guy can start.
Okay, I really enjoyed this, and I love the example. I think you should also make a kind of a business school case study out of this one. And this would be really helpful. It made me think about my favorite reading for the first class in labor law, and that's Klaus Offe, who argues that even if when you give workers collective action, you do not level off the playing field, and that workers collective action is not the same as capital's collective action. And therefore, I also understand how these two bodies of law, regulating law, are growing in disparate manner. So one question that I have is the political economy of this, which I don't know if you need to go into that in the article, but is there a synchronization in the thought about how to devise labor law as a limiting device to prevent cooperation and the antitrust law that denies positive cooperation? I mean, is there something going on there, or it's just two bodies of law that are being regulated by two different logics in two separate ways? So I wonder about the real life interaction between the two. I also had a thought about Kobi's argument that if you allow them to cooperate about good things, you don't know what's going to happen around in the table. So I would suggest the counter argument. Anyway, they're doing the bad things, and it's difficult to identify them. So why won't you nudge them to actually do some positive things? And I'm partially stating this because this is going to come up again in the following presentations on the private law issues, although admittedly more on cooperation along the vertical axis of the global value chain rather than between two supermarket chains. And you may want to differentiate between that. But I would think that the slippery slope that they may do negative things should not prevent from thinking in a positive way how you should induce or even mandate cooperation in the good things.
So I'll jump in as well. I really enjoyed the paper. I thought it really kind of very aesthetically shows how law kind of interacts with GVCs in a way that strengthens corporate power in such a almost like a closed system. It's really quite stunning, I think, to see it. It would be I know I don't have the space, but I just want to say that there are interesting examples for attempts of kind of regulatory bodies to create collaboration around specific workers' rights. So, for example, in the UK, under the Modern Slavery Act, the gangmasters agency that they have, the GLAA, created something called the Construction Protocol that brought together many construction companies, especially to overcome competition laws or kind of these antitrust laws. And Alex, who's not here now, Alex Troutterms, but will be here tomorrow, is, you know, if you were kind of want to hear how that worked, he was there around the table and can share stories about how the construction companies were terrified from being in the same room in this way. Eventually it collapsed, I will say. I mean, it was so difficult to do that it stopped. But I think the attempt of a regulator to do this and kind of say, no, we invite you. It was only around modern slavery. So it was not, you know, freedom of association or anything of the sort. It was the most extreme forms of labor market violations. But it was a really interesting experiment. Just as, you know, just as a thought experiment of how to overcome some of these challenges from the competition law side. From the worker law side, I'll just say that I just wrote a paper with Judy Fudge about strike law, kind of trying to show how in various jurisdictions strike law does exactly what you guys are showing here, basically an inability of workers to collaborate across jurisdictions and along supply chains. We show it in the case of Make Amazon Pay, and kind of how different workers along the Amazon, I guess you can call it supply chain. It's not exactly a supply chain in this sense, but when they attempt to work together, it's either impossible because domestic law disallows it, or it's impossible because domestic law is so varied that it's very difficult for them to overcome the differentiation in what they need to do in order to strike. So what workers need to do in Poland to strike is very different to what workers need to do in Germany to strike. And if German and Polish workers want to strike together, it's just this cumbersome maze. So, you know, that's, I don't know if that's another thing too. I know Trang is here and has done a lot of work on Vietnamese labor law and the way it hampers this, but, you know, maybe just kind of thinking about, you know, if they could, what would it look like? Could be interesting. Thank you. We'll take 2 more comments and then we'll let you guys respond. Is that okay? So class.
Yeah, thanks a lot. I really enjoyed this, and I found it interesting in the sense that the debate on competition law is usually, you know, very controversial on the 2 poles of seeing either competition law as, you know, a possible lever of change in that field, or to the contrary, you know, a field of law that really shouldn't go beyond its usual boundaries. And it seems that actually there's a lot to gain in the middle, in the sense that, yes, we do indeed have, you know, sustainability initiatives that come with an you know, greenwashing, anti-competitive, etc. impetus, and competition law properly understood could possibly become that field of law that actually differentiates between numerous initiatives, and then it really comes down to the type of normative assessment that it does of different forms of collaboration. So taking up Kobi's point on this. And I do find quite interesting on this actually how the European guidelines on horizontal cooperation have this kind of plethora just to propose a number of normative indications that corporations would need to satisfy. So being transparent in the procedure, not being imposing on actors that didn't subscribe to the participation, not covering a market share of, I believe, more than 20%, not sharing information that isn't actually necessary for the type of cooperation. So there are, I think, some normative items to play with that could allow to nuance this competitional analysis to decide what should pass and what shouldn't. And the second point briefly is that in the title you speak of regime collision, which also has been taken up a bit in international legal theory or so, but I see that I think you don't take it up again in in the paper. So I wonder if there's anything kind of conceptually to gain with this concept of regime collision.
Thank you, class. So let's hear Daria Kotova.
Yeah, hello.
Hi.
Thank you so much for the presentation. And well, as a competition lawyer, I have many thoughts, but my first would be my only would be, I mean, I understand the risks that competition law sees in all these kinds of cooperation. And again, as a competition lawyer, I think that these risks, especially in concentration markets, they are indeed quite pronounced. And there is a very active discussion in European law, European Union law, and European national law as to whether competition law really needs these exemptions for sustainability agreements, or it can deal with such kind of cooperation as it is now. Maybe these exemptions are not needed since they can increase cartelization risks. My question would be, I know that the ACCC, Australian Competition and Consumer Protection Commission, has issued recently a guidance on sustainability agreements. They do exclude, I think, everything except for environmental agreements, which is also, quite a weird policy choice for me. Maybe you can also comment on that, because all regulators really tend to limit sustainability to environmental considerations only, which is not true, because sustainability and labor, they're absolutely closely connected. So do you think that there's something in this guidance that kind of points to the possible relaxation of competition policy with respect to other sustainability considerations like labor, wages, etc., child labor? And do you think that the competition regulator there can be some advocacy effort to, with respect to the competition regulator to, widen the scope of agreements that it tackles in its guidance to also include labor, wages, etc.? Thank you.
So you have many things on the table, and let's take 5 minutes at most to respond. So pick and choose.
Ingrid, do you want to go?
Yeah, I'll take a few of them. They're all really useful, and I've written lots of notes. On the ACCC, as we call it, recent. So they put out a draft paper on how they treat sustainability collaborations, and they made it very clear, as you mentioned, that sustainability was just environmental. And there was which is obviously inconsistent with everyone else's understanding of sustainability. And there was a pushback, particularly from the anti-slavery commissioners, New South Wales, and that pushback had some effect in that the final guidelines that came out says basically it's, sustainability, environmental, and maybe modern slavery. But it's makes it very clear that to the extent that it deals with other issues, it's kind of modern slavery is purely for compliance with our Modern Slavery Act, which, as most people know, is pretty, weak, would be a polite way of putting it. So there's really, I think, and the other thing is that the guidelines basically just clarify the ACCC's approach. They don't introduce any kind of novel or new mechanisms. So there's really no regulatory reform to recognise broader sustainability. So I do think it's a real issue, I think. And I think there's a push from some areas to have a modern slavery exemption or authorization or standing, was it a class order, Shae, or something?
An authorization.
an authorization. But I mean, whether that's a good thing, because it would be so narrowly conceived that it wouldn't deal with a lot of the labour issues that we are concerned with. I'd just also say, Hilla, on the kind of regulatory agencies creating a safe space for construction companies to collaborate, that's really interesting, and I'd be interested to learn more about it. And I guess especially what was the role of the competition regulator in that, and were they sympathetic to that? And so I will follow up on that. And we should definitely reference your and Judy's paper on strike law in our paper, because that was a great paper, and I think it does fit really nicely with some of the stuff that we are saying. Yeah.
I might just pick up Guy's question, the political economy and the synchronisation. I do genuinely think, Guy, that this is regimes operating quite distinctly and quite separately from each other, and just assuming that with an exemption this keeps things completely separate and therefore we don't have to think about each other. I think Australian history has got quite a long background of that, particularly with policy reviews around this area. It's always just, well, there's an exemption for labour law, sits over there. And so there's no real thinking about the relationship between them, except to the extent that our competition laws do intercede in cross-business strike action. So they boycotts, sympathy action is unlawful under our competition laws, not our labour laws in Australia. And that subjects it to potentially criminal sanctions through the criminal cartel provision. So it's kind of a fascinating Australian kind of approach. The other comment I had was the regime collision. I do think we probably need to go back and have a look at that, because as the paper evolved, I think that we didn't actually take the route we were thinking with that, with that argument, but it stayed in the title. So yeah, I agree we need to have a look at that. And I also agree with Klaus about the fact that we do need to start exploring where labour law fits in the middle, where competition law fits in the middle in that grey area. And, until quite recently, ACCC was doing really fascinating things in the space, particularly around small business collective action, coming together with small groups around boycotts for business, not for employees. Really interesting stuff happening in that space that I think there's room to look more at, but probably not in this paper. I think Ingrid and I have maybe got 2 more papers out of this conversation today.
Thank you very much, Shae and Ingrid, for this great paper, and thank you, Kobi, for a wonderful response. We're going to take a 10-minute break, and we'll be back at 10:55, slightly after our supposed start time.